Legal options are explored in such situations by family members of the deceased where negligence occurred, leading to an avoidable tragedy and loss of a loved one. In cases we are instructed on of this nature, the family members have tried to get answers themselves, but these have not been forthcoming. We will give you a brief guide of this type of legal action in this post. This type of legal action has a statutory footing arising from Part 4 of the Civil Liability Act 1961. Section 48 of this Act states, where the death of a person is caused by the wrongful act of another, such as would have entitled the party injured, but for his death, to maintain an action and recover damages in respect thereof, the person who would have been so liable shall be liable to an action for damages for the benefit of the dependents of the deceased. An inquest may be required in circumstances where the coroner is informed that the deceased's body is within his or her district, and if the coroner is of the opinion that death might have occurred either in a violent manner or unnatural manner, or the cause of death is unknown. Legislative provision is provided to coroners for this duty under the Coroners Act of 1962. A fatal injury accident claim is different to a personal injury claim. However, it must nevertheless be submitted to the Injuries Board. If court proceedings are to issue, then permission from the Injuries Board in a document called an authorization must be firstly obtained. A personal representative of the deceased can initiate this legal action type. Section 48 of the Civil Liability Act 1961 states that the action may be brought by the personal representative of the deceased, or, if at the expiration of 6 months from the death there is no personal representative, or no action has been brought by the personal representative, by all or any of the dependents. Damages in a successful legal action of this nature will vary depending on the individual circumstances of the person taking the case. However, here are some examples. 1. Actual losses. This is the basic compensation that anyone can claim. All the expenses that the deceased dependents have for the treatment, for example, of the deceased person, are covered in this. It includes medical expenses, housing adaptations, medical treatment, travelling expenses, and funeral expenses, etc. 2. Loss of services. If the deceased person was providing other services like childcare, housework, etc. This can change from case to case, and an assessment of this will need to be done. 3. Loss of earnings. Often a spouse depended on the income of the deceased spouse, and therefore are now at a financial loss. 4. Mental distress. The dependents of the deceased can also claim what is known as the solatium. It is the amount that is awarded to the deceased dependents for the mental stress they had to bear. The maximum amount paid to the dependents is a fixed amount. Assessing losses is a complicated task, and the assistance of an expert for the loss computation is likely required. After the Injuries Board's process is concluded, High Court or Circuit Court proceedings will issue if a case commences. With cases of this nature, it is prudent to make a case plan at the outset for the reports and proofs that will be needed for the case. The reports needed for each case depend upon its facts, but it is necessary to assess liability and causation at the outset, so there is clarity about any legal path forward. If you wish to contact us with questions about such a matter, our details are 015461121 or 05261219999 or info@clearysolicitors.com.